Welcome to another episode of Image Rights by N. Mashinini, the only podcast dedicated to image rights in Africa and around the globe. Welcome to yet another episode of Image Rights by N. Mashinini. We are quickly wrapping up season 2, and I thought it would be a shame if I didn't invite a Zimbabwean legal expert onto the show, given the history between the two countries, South Africa and Zimbabwe, since season 2 is about an African perspective on image rights protection. So today I have with me Rutendo Mugdaza-Mugwagwa, and she is a registered legal practitioner and an intellectual property and technology law expert who is based in Harare, Zimbabwe. She is a holder of a master's in intellectual property and a registered member of the Zimbabwe Institute of Patent and Trademark Agents. She specializes in drafting and filing trademarks and patent applications, training research institutions and SMEs, governments, parastatals, innovation hubs, and corporate companies on intellectual property. I am excited to have this conversation with Rutendo. Hi, Rutendo, how are you?
I'm all right, thank you, Nomalanga. How are you?
I'm fine, thank you. So welcome onto the show. And I'm also quite happy that for this season, I finally have a woman on the show because I've had a series of male guest experts this season. Yes. So thank you so much for agreeing to do this. So your episode is quite a special one in the sense that we are not only focused on image rights, but we're focused on the intersection between image rights and intellectual property. Because it's quite interesting that when you look at the image rights regulatory approaches across the world, what you find is that most countries will put image rights in a personality rights context. And then typically in the States, what you have is that some states will also bring image rights into, or rather publicity rights in their context, into the intellectual property space. Because there's so much relation between the two fields, in the sense that obviously we can have copyright, for instance, over photographic and artistic works, but also those kind of works can contain people's identities and images. So I thought it would be a very interesting conversation to let the audience know and understand this intersection between intellectual property and image rights. So for starters, let's talk about the Zimbabwean approach to intellectual property protection, particularly for artistic works and photographic works. What is the approach in your context?
All right, thank you, Nomalanga. So when it really comes to your artistic works and your visual works, photographs, etc., they're mainly protected under copyright. So we have the Copyright Act, then governs what can afford it as copyright, what can afford it copyright protection, and what is eligible for copyright protection. So like I said, you have your artistic works, your musical, literally audiovisual, sound recording, etc. So generally in Zimbabwe, we are guided by the Copyright Act when it comes to anything related in the artistic world.
And so with the vesting of copyright in such works, let's say, for example, you've got a photographer who's been called in to take pictures in a photo shoot, maybe in a studio. When do we determine that that photographer or the person in the picture has certain rights in terms of your copyright legislation? Is there a registration process included, or is it purely based on contract? How do you approach that?
All right, so as of now, the registration process is also done at the Zimbabwe Intellectual Property Office. So mainly when it comes to copyright, I always tell people that copyright is tricky because it's afforded automatically. What I mean, like as soon as you take that picture, whoever is taking the picture or whatever the circumstance, there's no paper-based certificate that can certify to say you are the owner of this picture. So it just vests automatically, which can be tricky, and there's technicalities to it. So when you take a picture or when you write a book or whatever it is, something that is afforded copyright protection, you have to go to the Zimbabwe Intellectual Property Office with 2 copies of that work. So I'm speaking specifically when it comes to books, something that is tangible. You just go with those 2 copies of the book, you get a stamp, and then that's it. So when it also now comes to your images and etc., you have now commissioned someone to do the work for you, right? So it's purely based on contracts. Photographers, some of them nowadays, they now have their little contracts, whether you are a photography company or something, I ask you to come and take pictures at my wedding, etc. They give us contracts, can you sign, so that they can also then be able to distribute and publish those photos, whether on the social media pages, etc., as they want. And I also will then just have the right to also do the same, but I can't stop them from doing that because I would have signed those contracts. So it's based mainly on contractual basis.
Interesting. So have you ever seen any particular litigation trends where, in this context that you describe of the commissioning a photographer, where perhaps you see that maybe either one of the parties wants to prevent the other one from using the photograph? So either the client wants to prevent the photographer from using the photographs, or the photographer wants to use or prevent the use of their photographs by the persons depicted in those photographs. Because I'm just thinking about the J-Lo situation. I don't know if you saw this Jennifer Lopez situation where she had commissioned a photographer to take images of her, but then she took one of those photos and posted it on her Instagram profile. And the photographer wasn't too happy about that. So are there any sort of litigation trends that come up in this context in Zimbabwe?
So I think litigation will now even be a stretch, because the whole intellectual property system in general, in terms of litigation, the numbers are quite low because people still need to appreciate what it means. So now specifically with regards to copyright, I'm sure it happens. I wouldn't even lie. I'm sure it's something that happens. Generally, mainly because people don't understand the basis of a contract, and also because people just like to download templates. You know what I mean? They get a little template there, then they use it, and then they think it means what they want it to mean. So if you have someone like, speaking to the J-Lo example, I'm pretty sure the photographer knew that this is J-Lo. I mean, they first had to know this is J-Lo, you know what I mean? So, and because you are working in a system where IP is very rampant and it's overwhelming, people understand their IP. So someone can take advantage of that situation and have this contract then has a clause that speaks to that. And then also because you are busy, you don't have time. I can imagine J-Lo, it's just someone coming to take pictures. She would say, okay, just take the pictures and that's it, and assume she can use those pictures. But now, because of the nature of the person that she is, I'm pretty sure that's how the photographer had a leeway in terms of manipulating the situation. But now when you come back to the Zimbabwean context, I feel like, you know, in as much as, yes, photographers, we want them to take pictures of ourselves, whether it's in the wedding setting or whatever setting. It's a matter of both parties understanding that, okay, I'm asking you to do this job. You can do so much with the pictures, whether it's on your social media or whatever, mainly for your marketing purposes as well. So you can go ahead and do that, but it won't stop me from also using, because these images are of me. So I think it's still underwhelming because people don't really understand the context, like, okay, what does it mean and what am I going to put in the contract? So basically, I think that's how I can navigate. In terms of litigation, I personally haven't come across any story in the courts. I'm not sure, I haven't done my research as much, but I haven't come across something that's pending or that has been done when it comes to image rights between a photographer, for example, and a client. But I'm really sure that something like that does happen. But on the opposite side now, when a photographer now ends up, you know, sort of misusing your pictures, mainly because they're under the guise of marketing purposes and other guys that you signed a contract. So I think both parties just generally need to understand what it means and what they're signing and how they can then end up using the images as well.
Right. So let me move you a little bit into the sort of trademark space. Because what I'm also wondering is, with the rise of social media influencer marketing, often you find that the influencers are using their identity, their images on social media and their following to market a particular product or a service, right? And there's obviously an agreement between the company that's been marketed and the influencer. But I'm not quite sure if these arrangements will normally cover who owns the social media publications or the posts that drive the marketing. So who has rights over that, especially when you consider the fact that the trademark of that particular company that's been marketed is obviously being used in this marketing strategy. But at the same time, there's a combination of the trademark as well as the influencer's identity or image being used to drive this campaign home for the audience. So how are these normally regulated, in the sense that let me put it as a two-tiered question, in the sense that, firstly, what is the point of departure in terms of Zimbabwean legislation about the use of the trademark in this context? Who really owns the post for copyright, and what kind of use are we dealing with for trademark purposes here? And secondly, the second part is basically about what are the trends in contractual arrangements, parties like this, about who owns these social media posts. Do influencers retain ownership of their social media posts that involve social media campaigns, for instance?
I think that's a brilliant question, because I feel like, you know, everyone is now on this hype of influencer marketing. You know what I mean? But at the end of the day, there's IP issues that are sort of disregarded in a way. People can get away with it. People actually, like I said, people generally just don't even understand what it means to say, I own this copyright, I own this image, I am the owner of this trademark. So I feel like, okay, for influencer marketing, right, you are engaging a social media personality, right, because of the following, etc., to market your brand and whatever. So obviously, I'm pretty sure there's contracts behind this. I'm hoping, right, there's contracts behind this, and they must speak specifically to the IP, because also the influencer, right, is representing the brand. The brand, for example, could have been protected already, so they are representing the brand on their platform, and they are being contracted to come up with, whether it's a skit or whether it's content creation or whether it's whatever, mainly solely for that company. So it will be advisable for the company to at least have a specific clause that speaks to it, so that the influencer understands that, okay, this work is specifically for this company, and this kit is specifically for this company. And when you're posting specifically for this company at this time and at this duration, and how many hours and how many times you're going to post it, mainly for this company's marketing purposes, to gain financial revenue, or to gain financially from your following. So now influencer, because they also want money, you know what I mean, they might not understand that, okay, fine, this is specifically for the company. So if it means if I'm commissioned again by another company to do something along the lines, or a competitor or etc., I can't do that, mainly because the concept and etc. belongs to this company. So it goes back to people really understanding that, what does intellectual property mean? What is a trademark? What is copyright? And what is afforded as copyright protection? If I come up with the skit myself, does it mean the work belongs to me, even though it's being represented by this company? Or is the company's marketing department going to come with the concept to me, but I'm just going to either follow through or maybe act or just post? What does it mean? So it's those technicalities that I feel like accompany each and every contract and each and every influencer. And I feel like the contracts themselves, because people, I'm always just like, guys, you do understand that whenever, as an influencer, you're running a business, you yourself, you are a business, right? That is why we want you to represent us, or that is why we want you to represent our brand. So in as much as it is a business, you must also understand that when it comes to a business, you need legal advice, right? You have people that advise you and tell you, all right, this is this little clause in your contract. Did you see it? Do you understand it? What does it say? But because we are looking for money, we're hungry for money, people don't necessarily have the time to read, and they just sign away their lives. And then also, does it mean the company that is asking you to do their marketing, is it for a specific time, or when you are done, let's say the contract is done for 6 months and they no longer need your services, does it mean they're not going to keep on posting your images, or not going to keep on associating themselves with you, even if you are done with the contract? Probably this is, let's say, it's a 6-month marketing campaign. After that, whether we have sales or not, we are done. But does it mean 2 years later they still can't? Because now the market believes that you represent them, and probably contractually you have stopped, and we don't know that you can now necessarily announce that, okay, I'm no longer working with this company. So in 2 years' time, they can still use your images and associate them with your products. And what do you have to say about that? Do you know that these things can happen, and do you know where you can get assistance? So I really think it's quite deep. It's quite deep for me, and I think it's just, it goes back to the both parties, if they're both understanding what they're signing and what they're getting into. I hope I've answered both the questions.
So what I'm getting from you is that it's a highly contractual issue, in that the legislation itself does not address these specific issues. What I'm also thinking about is, I've recently seen an increase in companies now avoiding to have to book a session with an actual person to do either an advert for TV or radio or whatnot, and sometimes even avoiding to sign up an influencer who's going to run with the campaign, but rather replacing that with the use of deepfakes, so your artificial intelligence created artistic works. And there is a rise in questions about, can even AI produce artistic works? Would there be copyright over that, and so forth? There are very interesting questions about that. But what is quite clear is that even in instances when companies want to use deepfake images of people, even influencers or celebrities, they'd still have to request permission from them to sort of sign away the rights to use their image in that kind of a composition. But I'm not quite clear on whether these issues have come up in Zimbabwe. Are deepfakes a well-recognized thing in Zimbabwe? Are there any questions coming up about particularly intellectual property and image rights in the context of these deepfakes in Zimbabwe?
Okay, so generally, I feel like AI itself is still a confusion, right, to begin with, because people have this, okay, is AI going to take our jobs? That's number one. All right, how far can AI go? So, and copyright is one of them, because, like you were mentioning, there's the whole deep fakes and memes culture and all that. And it's still a gray area of intellectual property, if you ask me, because sometimes they can come up as original creations, right? And copyright can arise automatically, probably like in a newly created meme, provided that the content is original, is an original work of authorship, because it goes back to the originality and the creativity, as long as it is expressed in tangible format. So someone can then claim and say, okay, fine, we came up with this concept, although it's a deepfake, but we did it mainly because it's a parody, and we did it because we're trying to send a message or something. And then people can easily get away with that and write on like the fair use doctrine, which is also explained in the Copyright Act, which mainly speaks to the categories of works which can be classified as fair use. So your parodies are there, your speeches are there, anything educational, etc., can be classified under the fair use principle. So I feel like people are still doing it, or they could be doing it, and people who actually even understand AI, your techies, your tech gurus and stuff, they can get away with it because the legislation itself doesn't speak to it. Because as you know, I'm not sure about South Africa, but like maybe for Zimbabwe, our legislation, especially when I'm looking at the IP legislation, right now the Copyright Act actually is now in review. We did submissions last year, no, beginning of this year actually, just so that the laws can now adapt to technology, one, and appreciate technology, because like you said, artificial intelligence, who knew it was going to be something that we can talk about now? But these laws were done maybe 20 years ago, 30 years ago. So now they specifically need to speak to your AIs and to your technology so that we understand. And so that when someone claims or someone wants to sue someone because they've used their images or they've done a meme or they've copyrighted or they've infringed on the music or infringed on their pictures, used their images, etc. At least you have the law that speaks to that. The law can also then relate. So in terms of legislation right now, it's still work in progress, also because we still need to also understand what artificial intelligence is and if we incorporate it into our laws, and what are the shortcomings and what are the advantages that can come with it. So obviously those issues to do with your deepfakes and your memes and etc. can also come out. But because someone who already understands it can find a way to navigate themselves, like I said, they can say, okay, it was a parody, and this was mainly we didn't even financially gain from it. It was just because we're doing it because of that. And then they include your right to privacy and whatever. And then it becomes something that is so complicated, but mainly because people just generally don't understand, or we are not also appreciating technology and moving with the times in order to accommodate some of these issues when they arise.
So would you say that copyright would vest in parodic publication? So maybe a meme that's a parody or a deepfake that's published as parody, would the publisher have copyright over that publication in terms of Zimbabwean copyright laws?
In terms of, as long as they can sort of like hide behind the fair use doctrine, like I mentioned, right? As long as they can hide behind the fair use doctrine, I feel like they can sort of get away with it. And also if they have someone who's, what can I say? I don't want to speak for myself, but like a clever lawyer, for example, who can sort of run away with it and then indoctrinate or incorporate the fair use principle, where you can get away. Because I feel like in South Africa there was a case, was it an SAB case some time ago or something?
Buffet of
Right?
promotions.
Yes. That's where there was some sort of talk around it, especially in Zimbabwe, on the chances of it qualifying under fair use, or how people can actually navigate around it. And obviously, if there's no case law that speaks to it, judges always just refer, you know what I mean? So they can use laws from outside, and then they would then see how best they can come up with something that accommodates it. But as of now, I still think it's happening. It's definitely happening, but people don't know where or how to report or where to go. And people generally just think, because it's a meme, so I can just do it, right? And they write on this whole, like, it's a meme, so what can you do? What does the law even say about memes? Does the law speak to it? They don't at the moment. So, I mean, I can get away with it. So I think that's the biggest disadvantage that we have at the moment. But like I said, the Copyright Act specifically right now, it's in review. There were submissions that we made. I specifically didn't submit with issues to do with this because I think I wasn't thinking about it at the time. I was thinking about other things. So I'm just hoping that the other people who also contributed, at least there's someone who spoke about it. But I know there was something with regards to social media. So I'm hoping it will also cover all that because I think this generally just happens on social media, etc.
So speaking of social media, according to your Zimbabwean copyright laws, do people retain copyright over their social media posts, especially when they post like selfies and so forth? Who holds the copyright over those publications, or is it solely dependent on the social media user policy and user agreement?
I think it generally depends on the social media policy, Because I feel as much as the research that I've also done, I always advise people to read, nobody likes to read those terms and conditions and the privacy policies. But I think the social media platforms themselves, they're also now trying as much as possible to make people understand when it comes to their images and how they can use their images and how the platform can also use their images. And I think, I'm not sure if it's not Facebook that solely tells you that, okay, these are your images and you can do whatever that they want with it. They can't, I'm not sure if it's Facebook or Twitter. I need to research more, but I think some of the platforms are now sort of, accommodating the fact that they can actually end up getting into trouble because of image rights and use people's images, etc. So people now, at least when you join a platform, okay, if I'm posting these pictures, they belong to me. Now the problem comes if someone then takes those pictures from my platform or my social media account and then use them without my authority. If I want to then engage, for example, I know YouTube does that, right? Like a takedown policy, etc., like a copyright policy, they have a strict one. So if even Facebook now, they also do. If I raise that issue, someone can then be taken down, but it's mainly on you understanding that, okay, someone used my image, right? Do you even know where they are? Can you even locate them? That's the biggest problem. Because they might use the image, let's say images of like a city, not images of your face, for example, but like, those town night light pictures and etc.
Yeah.
It was a case where there was a bank that did that, right? They took someone's image, photographer, they edited their pictures, they posted it. So this bank, when they were introducing their app, right? Their mobile-based application, they took that picture and put it as a background picture for their app. So he then claimed that on social media again that, look, they're using my picture, etc. I tried engaging them. I don't know where it went, but it went back to, did he even understand? Or he was like, because it's bank, so I probably don't have the financial muscle to go against the bank, so it's fine. Or maybe the bank went to him silently and said, okay, fine, we use your image, we can pay you. And then that's that. But they had infringed initially. So people need to understand that, okay, yes, your images belong to you, but are you able to monitor who is taking your images and where and how they're using them? So I would also want to maybe mention that I'm actually working on a project that speaks to that, also incorporating artificial intelligence and blockchain as well, just to make sure, because like I said, I'm also very passionate about this, or intellectual property rather. So there's a system, or there's a project that we're working on with one of my co-founders, mainly that speaks to issues to people, how they can monitor their works on social media platforms, and be able to then end up suing, or to at least raise some sort of notice or get some sort of legal advice when it comes to people using your images or people using your works without your approval or authority.
That's interesting. I'd be interested in how that kind of use of blockchain would assist people to particularly protect and trace the exploitation of their images from an image rights perspective, obviously. Because one of the things that I focused on in my doctoral thesis was basically about image rights protection against memes. Because we have a very strong meme culture online, where people will typically they'll use politicians, celebrities in memes, but there's also a very strong culture of using children in memes and putting a caption on the meme. But no one pauses to think, when I circulate this, whose baby is this, whose child is this, or whose mother, whose brother, whose father, who am I actually exploiting for my own pleasure and my own laughter when I circulate a meme? Because I think the first question we have to ask is, when I post my selfie, for example, on Facebook, am I really signing away all my rights over that photograph? And the answer is no, because at the end of the day, your photographs are very linked to your personality, and you can never really sign away or sell your image per se.
Mhm.
You can maybe sell a particular material composition, or when it's reduced to a material photograph, you can sell a photograph, but you can't really sell your image, your identity. And so the biggest problem that I have with what social media has been doing to people all over the world actually is to reduce human dignity through these image rights violations. Because, for example, in South African law, merely using someone's image without their permission can actually violate identity and even privacy. And that's why I've been asking also this question of, do I have copyright over what I put up on social media? Because if I do, then also taking that without my permission is also somewhat an infringement of copyright if I do have copyright over that. Yes, indeed, there will come some freedom of expression defenses. There will come in some fair use exceptions that we also have in the South African context. But I think in instances, particularly of children, we need to be very careful about how we apply these issues or these rules, rather, to determine whether there's sufficient protection for people's images and exploitation of people's personalities online. So this is why I wanted to have this conversation about what does intellectual property have to do with it, basically. And how do people regulate this, especially also when you look at the influencer industry, because it's booming, it's rapidly growing. And I think there are a number of people who step into that market as influencers, and they don't even know the ramifications of the industry that they are partaking in, or the consequences that flow from signing deals with these marketers about how to use your image to sell their products and so forth. Because, you know, I've always thought to myself, in the past, before we had social media, we had instances where companies would take celebrities' images without their permission and use them in advertisements, right? And it would often spark litigation because obviously a celebrity would have financial muscle to go after them. And also, it would also be about managing their reputation. So there's a strong case for a celebrity to come through and say, I don't appreciate that you're using my image in your advertisement. But when we're in this social media world where companies engage with their consumers online, you know, for example, I could just go on Twitter and tag a particular company to a post, right? And vice versa, a company could also tag me to a post. That association or that impression that it creates definitely gives rise to some image rights questions. But in addition to that, what intellectual property questions come up? Because I tend to ask questions about also, if I tag a company also, I'm using their name, I'm using their brand in my post. What are the confines of trademark regulation there? Would it mean that I'm violating their trademark or infringing their trademark by using their name like that? Or does it depend on the kind of use that we're having? Because in the South African context, trademark infringement normally has to do with the manner in which you're using a person's trademark. So when you're using it as well for marketing purposes, for instance, use in trade, use in commerce, it would attract liability. But to just use it for parody purposes, like in the Laugh It Off Promotions and SABS case, that wouldn't attract any consequences. Because, for instance, in the Laugh It Off case, what happened was a particular group of people decided to make a T-shirt using the Carling Black Label logo, but they had tweaked it for social comment. And that was actually not considered trademark infringement when Laugh It Off Promotion CC actually did that, because there was no substantial economic harm that SABS actually felt from that use of their trademark. So I think what the audience needs to understand from our conversation is that, yes, even though you have image rights and you have intellectual property regulation coming from the legislative and judiciary perspective, you also have a very strong freedom of expression to use these copyrighted and trademarked aspects of people's entities and personalities in a fair manner, provided that you can justify why you are using their stuff. So these rights are not 100% exclusive in that sense, because you've mentioned fair use already. We're now talking about the issue of parodic works, and all of these tie in with image rights and intellectual property. And I think it's quite important for people who are interested in also becoming influencers to understand how this works. So it's quite an interesting conversation that I think the audience will definitely benefit from. But I think perhaps what we should also just quickly touch on in closing is, what would you say to someone who is looking out to become an influencer, or has just maybe gotten a deal to become an influencer or do an influencer campaign for a particular company? What are the 2 tips or 1 tip or that you would give to them regarding this particular conversation around your image rights and intellectual property in this context, especially when it comes to them signing agreements with these companies?
I feel like just have a lawyer. I mean, I don't think I can express this.
What if I can't afford a lawyer?
You see now, that's the other problem, where people are like, I can't afford. But like I said, you are running a business. Yourself as an influencer, you're already a business. So in terms of business, there's expenses that you need to cater for. And having legal advice is not an expense. I feel like it's an investment, because it will save you the drama at a later stage. So I was watching the Chilla's podcast, that for MacG and something from SA. So he was saying he wanted to enter into a contract with a music distribution company, right? And it was like 30 pages. He had no time to read that. But luckily, he invested in a lawyer. So he asked, can you please review this contract for me? It could be a good deal, etc. And there was a specific clause that mentioned that after 3 years, that music distribution company was going to own all of his works for the rest of his life. And imagine you don't have a lawyer, you don't have someone to review or read through something for you, and you sign away your life because it's a good deal. It's a good money deal. They'll offer you $2 million upfront, in terms that are negotiable, in terms that are favorable, and you think it's fine, it's the best deal. I didn't have the $2 million in my bank account right now. I would appreciate if I had it, so let me sign. I don't have the time. So you sign away your life just because you have sort of neglected some other components of your business. Have some sort of legal advice, have some sort of legal person who can at least assist you in reviewing this type of contracts before you sign away your life. It's a good deal. Influencer marketing is something that is growing, like you mentioned, and each and every person, as long as you have a significant number of followers, you automatically feel like you're an influencer, right? And because it's a cheaper way of marketing, for companies, unlike advertising on a billboard or etc. It's a cheaper way and a faster way of engaging the market. So they come up with a shady deal for you, and you think it's the best thing that has ever come, and you sign away, and you don't have someone that can at least help you, especially when it comes to your money, your IP, and as well keeping your brand and keeping your business running. So I feel like as influencers, you need to go back to the drawing board before you sign. Okay, understand that you as a person or as a brand, you're a business and you're running a business, and what does it entail to run a business? That's why companies have lawyers in-house, because they know these things. They know things like this will happen. So they were like, okay, or they contract other law firms to then do the work for them. But because you're running a business, we might get into trouble sooner or later, or we might need advice here or there on issues to do with, because the marketing department is overzealous. They will tell you, we've seen, okay, this person is trending, they've got 1 million followers and whatever. If we target at least 100,000, a tenth of those numbers in terms of our target would have reached, right? Because they are marketing, that's all they do. They don't think of the legal ramifications. So the marketing department as well needs to understand the implications of intellectual property, because they themselves are the ones that are putting these large corporations into a mess, because they are overzealous. They think an influencer is there, and then someone educates the influencer and tells them, but you know what, they're taking advantage of images. They're not supposed to be using them in this campaign. They say they'll specifically use it for this campaign, but they're not using for every other campaign because they've made you their brand ambassador. So it means they can use your images at whatever point they want. But are you making money out of it? No. And is the company making money? Yes. So it starts from the marketing department as well, because they're the ones that approach the influencers. So it's like a love triangle: the marketer, the company, and the client. So yeah, I think that's how it should work. I hope I've answered the question.
Sure. And I think also for legal startups and even big law firms, maybe the whole idea that you are looking to pioneer around tracking and tracing using blockchain technology is quite an important thing in this age, because of the way in which there's so much information on the internet.
Mhm.
It is very hard to keep up with who's saying what about you online. Honestly, I remember a time where I went on to Google, because every year I do an audit, a self-audit, to see what is out there about me, because I want to manage my identity. And I found out that I had been associated to a conference that I had never been to.
You
And
lie.
I can't make this up. And I'm
Wow.
actually going to be doing a podcast episode about that in the last episode of this season, to just share my personal story relating to image rights issues, because it was the most absurd thing. And when I tried to track them down and tell them to remove it, I wasn't really successful, but I'm still fighting that fight. So yeah, it's quite important for people to learn to audit their identities annually, I'd say, and look out for what is out there about me. Where are my pictures being used? Because, you know, the challenge with social media is that it creates a one world kind of system where there are no geographical boundaries. So I may not know if someone in Zimbabwe has taken my image and is putting it on a bottle of Coke or a bottle of something like that. You know, maybe Coke is not the best example, but you see, you never really know how far your identity goes because of the online world. So I welcome the project that you're going to be working on relating to tracing your works, including your intellectual property works as well. You know, so I think in closing, could you maybe share with the audience what your foundation is about? Tell us about Zilta and where people can contact you. What is Zilta about, and how we can even contribute to this?
All right. Okay. So Zilta is Zimbabwe Innovation and Legal Tech Association. I think it was one of my passion projects, because I felt like, all right, fine. Generally, just being a lawyer, people automatically assume, or we are rather indoctrinated into this traditional way of thinking that, okay, it's either you're in the law firm, or it's either you're in corporate, or it's either you're in the judiciary service system. But not everyone gets the opportunity to get that job. So, but people have so many ideas, and there's so many problems that we haven't even begun to even attempt to address, mainly because, like I said, we can't afford legal services, right? That's the biggest problem. So we are trying to come up with legal tech solutions that accelerate access to justice, number one, and access to legal services, and also making the law itself flexible and understandable, as well as efficient in law firms as well. So we are generally just like a hub of young individuals that are trying to come up with several legal tech solutions, brainstorming and trying to put them in the market, and seeing how best we can tackle this whole issue around whether it's intellectual property, whether it's even estate planning, right? As long as it's something that's related to the law, we are trying to tackle and come up with something that is tech related, that then feeds into the market and solves a specific problem. So like I said, the intellectual property issue of you having your images online or having your copyright works online and not knowing where they are or who's using them, but then being infringed out there and not knowing where to even go. How can I report? Who do I even report to? So we are like in the process of conducting like a survey where we feel like we need to at least understand what the problems are. Do people understand what copyright is? Do people understand where to register, or if they can register their copyright, and understand where to report if someone uses their idea or someone steals their idea without their authority? So that is the biggest project that we're working on right now, to incorporate artificial intelligence, like I said, as well as providing some sort of ownership. I think in the beginning I mentioned that here in Zimbabwe specifically, they incorporate this automatically, right? So if I write my book here and I put it in a journal or whatever, I can just be afforded copyright protection because it belongs to me. I'm the one who wrote it, right? So there's a whole lot of theft, intellectual property infringement, etc., because I can't specifically prove that, guys, I'm the one who wrote it first. This is my book. I'm the one who journaled it first. Unlike trademark and patents, where you actually receive a certificate on the day of filing that you're the one who filed first. So that is the system that we're working on in terms of so that someone can be able to prove, number one, that they're the copyright owner of that work, and as well as someone can be able to track and see who is using their works worldwide, regionally, or locally. So yeah, stay tuned. It will be launched very, very soon. But I think generally that's what we're doing in Zolta. And it's an association of young lawyers who, some of them are still in practice, some are not, but we're generally just a hub of lawyers coming up with tech-driven initiatives just to accelerate access to justice, access to legal services.
And where can we get in touch with you and Zolta?
Yes, so, well, our email address is info@zolta.co.zw, or you can even catch me on LinkedIn, Rutendo Mugdaza-Mugwagwa. That's my username, and what other social media platform? I think Facebook as well. An email, like I said, it's info@zolta.co.zw. Contact number, it's +263 773 238 568. So, right. Yeah, I think that's about it.
Okay, thank you so much for being with me today and having this conversation from a Zimbabwean perspective. I'm sure the audience have enjoyed this very informative session. I look forward to working with you and Zolta in future.
Definitely. Thank you so much for the opportunity, Nomalanga. And thank you to the listeners as well.
Thank you.
Remember to control your image rights.